Hello everyone, welcome to International Commercial Arbitration. We're now going to discuss the process of the arbitration. Anyone who is dealing with international trading must understand the process of arbitration. Traders should know how arbitration works and what to expect during the process. Somehow it has a similarities with traditional court case, but the fundamentals are really different in process. For the chapter 5, we have three objectives, and these are: first, it is understand the fundamentals of arbitral process. Second, identify the nature and manner of arbitral proceedings. And lastly, let us understand the tribunal jurisdictions and its obligations. To easily understand each term, let us explain them one by one. When we say tribunal, this is the court of justice. And secondly, inherent, meaning vested in someone as a right or privilege, or he is being appointed, like the arbitrator, he is being appointed, okay, to be to be the mediator or to arbitrate the dispute. The third one is jurisdiction. So this is the official power to make legal decisions and judgments, okay, basis on the submitted evidences. And the power, okay, this is the authority given to the arbitrator or the capacity or ability to direct or influence the behavior of others or the course of events. And the last one is the obligation. This is the condition of being morally or legally bound to do something, because an arbitrator, if they're going to make the decision, it should be in injustice, and they're going to treat both parties in equality. You could see here is the arbitral process. The arbitral proceedings is the step-by-step procedures on how arbitration is conducted from the start of application down to the final decision of arbitration. The step-by-step process is: first is case file, or you're going to file the case. Second is the selection of arbitrator. We already mentioned that it should be one or three depending on the institution. Third is the preliminary hearing and scheduling order. Fourth is discovery process. Fifth, hearings or mediation. Sixth, arbitration hearing. Seventh, post-arbitration briefs. And the last one is the final arbitration award. The first step in arbitral process is the filing of case. The arbitration case begins when one party submits a demand for arbitration to the institution. The other party, that is the respondent, is notified by the institution and a deadline is set for a response. Together with the application form, the claimant should pay the application fee, and he's going to submit a particular documents like a sworn statement, okay, or it is a written document wherein it stated the nature of the arguments or the nature of dispute or what he is claiming for. And also, it is unnecessary for the claimant to submit the contract of sales as the basis of the claim. The second step for arbitral process is the selection of arbitrator. The institutions work with the parties to identify and select an arbitration based on the criteria determined by the parties. We already mentioned the qualifications of an arbitrator must have the basic knowledge of the legalities or technicalities of arbitration processes, and so as the arbitrator must have the full knowledge of the nature of the dispute. Different institutions have a particular process on selecting an arbitrator. Selecting an arbitrator is always based on the agreement of both parties. In other institutions, they're going to show you okay, a list or a roster of arbitrators' name, and it's up to the claimant and respondent, okay, who are they going to select to be the arbitrator of their disputes. The third arbitral process is the preliminary hearing and scheduling order. What happens during this process? The arbitrators conducts a preliminary hearing with the parties to discuss the issues in the case and procedural matters. It is more on like a briefing or orientation what will happen throughout the arbitration process, including the regulations on presenting the witnesses, depositions, sharing informations, and other matters. When we say depositions, it is the process of giving sworn evidence. So these are the written evidences or written statement by the respondent and the claimants. For this stage, the step number 4, the discovery process, the arbitrator conducts an investigation and validation of the evidences submitted by both parties. So at this time, the arbitrator is going to weigh and check if there will be some evidences that are missing, information that are missing, or documents that must needed to be submitted. The fifth process is the hearings or mediation. The parties then prepare for presentations and exchange information. So this is not yet the formal hearing. Okay, the arbitrator is just going to give a chance for both parties to defend themselves out of the tribunal court. It's like a mini mediation process prior to the hearing proper. In this stage, the arbitrator might have some modification or clarification of the evidences or information that had been submitted, so that during the hearing, the hearing proper or the arbitration process, the arbitrator could be able to establish the information or what really the nature of the claims and what is also the claim or the respond of the respondents. In the sixth arbitral process is the arbitration hearing. So this is now the arbitration proper wherein both parties is going to state or present their testimonies together with the evidences to the arbitrator. Unless the case is very complex, this is usually the only hearing before the arbitrator. So it means that if the dispute is really big, okay, that's why it's very important to have a briefing prior to the arbitration process, and there is a discovery of evidences, because all of the evidences will be presented here. All of the claims and the answers of the respondent will be presented during these hearings, and this will be the major and or the only arbitration hearing that will take place throughout the arbitral process. For the seventh step of arbitral process, we have the post-arbitration brief. So what happened during this stage? After the hearing, both parties may present additional documentation as allowed by the arbitrator. And if in case there will be some missing or forgotten documents that is needed to be submitted in the arbitration office, okay, they will be given an opportunity to supply or supplement documents for their claims. After the evidences had been presented, the arbitrator is going to evaluate and analyze the situation and all of the presented evidences and information. Okay? Finally, the arbitrator closes the record on the case and issues a decision, including an award if applicable. And at this stage, the final stage we're in, the arbitrator is to give a verdict, okay, or the final decision of who is in favor Okay, who will gonna get the favor of the award, either the claimant or the respondent. So at this stage, the arbitrator will determine if the claimant's claim is really true, or he has all the right to claim, or the respondent, okay, had defended himself, okay, very well, which makes the dispute favorable to his side. The final award may also decide upon the interpretation of contract terms or determine the respective rights and obligations of the parties to a contract. As I told you, whatever it is written in the contract, it will always prevail unless it is being waived by both parties, or there will be some amendment or changes that have been neglected and forgotten to be recorded. Okay, that's why contract of sale is a very important. So this will vary, okay, the obligations and the duties of both parties. In the ancestral model law in international commercial arbitration, or the model law, where Articles 32, uh, Section 1 states that the arbitral proceedings are determined by the final award. When a final award is made, the authority of the tribunal ends. And lastly, an award is final given that it produces res judicata effect between the parties and can be challenged or enforced. Remember, whatever the decision in arbitration process is final and you could not appeal it. If you want to appeal, what will happen is you're going to appeal to the higher court. Because remember, whatever the decisions in the dispute that will take place is with the consent of both party, and it has undergone a series of evaluation and analysis. The final award must be studied well to implement equality and fairness for both parties. The tribunal court has an important role and must given a careful considerations, like there are so many provisions, rules, and laws that would identify the tribunal obligations. It should be within the will of both parties, subject to limited restrictions as may be appropriate for public policy. Remember, a tribunal has no jurisdiction to do anything until it is fully and properly constituted. It is specifically set out in the domestic acts and implicit in the definition of the arbitral tribunal in the model law, if you're going to follow the ad hoc. But if you're going to follow the institutional arbitration, whatever is written in the arbitration agreement, you're going to follow the institution rules and regulations. But then again, it should be under with the consent of both parties. Here are the parts of arbitral proceedings, or some of the considerations that must be undertaken throughout the arbitration process, and considering the tribunal obligations must be covered within this part of arbitral proceedings. First, we have the conduct of proceedings, rules governing the proceedings, procedural timetable, additional submissions, amendments to claims, defense and counterclaims, joinder of additional parties, single arbitration under multiple contracts, consolidations of claims, place of arbitration, pleas as to the jurisdiction of the arbitral tribunal, evidence, experts, language of the proceedings, applicable law, hearings, closures of the proceedings, conservatory and interim measures, default and withdrawal of a claim. We're going to define and explain them one by one. So let us discuss one by one the parts of arbitral proceedings. For the conduct of proceedings, this is the manner, on how the arbitrator is going to treat both parties with equality and given a fair opportunity to present its case at appropriate stage. Why in appropriate stage? As I had mentioned, that you are going to submit the documents in a particular period of time. You have to follow the timetable. If in case you fail to submit the documents or supplementary evidences, it will not be honored by the arbitrators because it will cause delay with the arbitration proceedings. And secondly, rules governing the proceedings if the nature of dispute has a relation with the society or the violation with the substantive law or community, and it will follow the substantive law or the government law or the national law. And if it is only pertaining to the nature of the dispute, like violation of the contract, not following what is written in the contract, therefore you're going to follow the institutional law or rules that had been reflected in the contract of sales and the arbitration agreements. And the third part is the procedural timetable. It pertains to the schedule of proceedings. There are set of schedules that must be followed by the time of the application until the respondents answer the complaint to them, okay, or to him. Then the fourth one is the additional submissions, okay. This will require the respondents to submit a counterclaim within 30 to 45 days. This is according to different institutions. So the average is 30 to 45 days. So therefore, the respondent must comply or submit a counterclaim or answer to the complaint within 30 to 45 days. And the fifth part is the amendments to claims, defense, and counterclaims. Okay, the arbitrator or the arbitration tribunal will give an opportunity for both parties to do some revisions or changes and submit supporting evidences, okay, within a scheduled time. Because if they're going to wait for the claimant or the respondent to submit without any restriction, it would cause delay and it would take a lot of time and consume a lot of time, and it will be unfavorable for both parties because they're going to pay for the arbitrator's fee. The sixth part of arbitral proceeding is the joinder of additional parties. So it pertains to the additional party may be added if both parties agree. Remember, international commercial arbitration is only covered by two parties, okay, the claimant and the respondent. Okay, unless both parties agreed that they could include additional party, okay, it will be permitted by the arbitrator. According to International Chamber of Commerce, no additional party may be joined to a dispute after the confirmation of appointment of any arbitrator unless all parties agree otherwise. And the seventh part is single arbitration under multiple contracts. The Secretariat may allow submissions of claims arising out of multiple contracts within a single request as long as it is also within the nature of dispute or it is also the within the party of claim or the claimant and the respondent. But if it involves other party, it will not be acknowledged and it must be undertaken with the other arbitration proceedings. And the eighth part is the consolidation of claims. And in case that there will be a lot of contracts, okay, under the same party or the same respondent and claimant, okay, the secretary can combine all of the claims and take note again depending on its nature. And the last part for this slide is the place of arbitration. The place of arbitration will be determined upon the agreement of claimant and respondent, okay? And also with the guidance and suggestions of the institution. Why? Because if it will be held out of the institution's country, or the most accessible place for the respondent and the claimant, it will entail, or they need to pay for the travel expenses of the arbitrator. That's why, as much as possible, the place of arbitration will be accessible or near, okay, for both respondent and the claimant. The 10th part of arbitral proceeding is a pleas as to the jurisdiction of the arbitral tribunal. Arbitral tribunal have the power to accept or reject the petitions, whether it is valid or not. Arbitrators that had been selected and appointed are well equipped with the skills and the legal information. Therefore, upon the proceedings, they're going to evaluate and analyze the dispute, and they are going to recommend the award based on the evidences presented by both parties. That's why, if in case there will be some pleas or request by any of the both party, or if there will be a request from the respondent, or there will be a request from the claimant, okay, the tribunal court or the arbitrator is going to study it well, whether it's going to accept it or reject it. And the 11th part is the evidence. These are the relevant translated documents, contract of sales that will prove the claim of the respondents or the claim of the claimants. 12 is expert. Okay, these are the professionals with full knowledge of the case, especially with the legal matters and the nature of the dispute. The 13th part is the language. It should be agreed by both parties, and normally if the dispute involves by different countries and with a different language, English is being used as the second tongue. The 14th part is applicable law. Okay, it is written in the contract of sales and is also written in the arbitration uh, agreement. Remember, before the proceeding to be conducted, there should be a policy set of rules to be followed. Okay, rules that will not just favor the claimant, but also it is a universal rules and regulations if it is pertaining to the society or community regulations, and of course the governing law wherein it is stated in the contract of sales. Hearing, this is the process wherein the claimant and respondent is going to present their evidences, and the arbitrator is going to listen to their presentation and evaluate and weigh if both parties telling the truth, or there's the information that they had provided has a relevance to the nature of the dispute. And we call it hearing because literally the arbitrator is going to hear the opinions of both sides. 16th is the closure of the proceedings. If both parties are satisfied with the presentation of cases and the undertaken process, the arbitral tribunal will declare the proceedings closed. But before the arbitrator is going to close the proceedings, he is going to check if all documents are submitted, if all of the defense or testimonies had been presented. Then that could be the time that the arbitrator could set the proceeding close. 17 is the conservatory and interim measures. So when we say interim measures, it's temporary or short-term solutions or actions while waiting for the final award. After the proceedings, okay, the arbitrator is going to mention that both parties should not take any actions that will affect, okay, that will affect the decision makings, or that will affect with the process of arbitration, because when the proceeding is already closed, any additional evidences or information that will be given by both parties will no longer be materialize. It will no longer be accepted because the proceeding had been decided or declared closed. And that is interim measures and conservatory. No actions to be taken. Okay. And 18 is the default. Okay. When we say default is failure to respond, okay, or to file an answer, or it is a failure to present evidence and appear to the court. If that's happened, arbitration tribunal will proceed with the arbitration and will provide an award basis on the availability of the evidences or information that had been presented before the arbitration. That's why it's very important that when you receive a demand letter, you have to comply and explain, because everybody will be given a privilege to explain themselves. Okay, if you keep quiet and silent, and then you are going to lose your opportunity to present yourself not guilty or to present yourself free of those accusations. And the last part is the withdrawal of a claim. If in case that the claimant feel burdened, or feel like um, I should rather not to do this arbitration process, the claimant may cancel or withdraw its complaint. But if the respondent already submitted its answer, the respondent must agree if the withdrawal must be proceed or not. Why? Because if I am a respondent and then you're complaining that I had done something wrong with the contract, it's a different thing. Therefore, to protect the credibility of the respondent, okay, the respondent could defend himself, and then he has also have the right to cancel the withdrawal of the claimant. The respondent could decide that the proceeding must be continued, and that would complete the parts of the arbitral proceedings. The final award must be studied well to implement equality and fairness for both parties. The tribunal court has an important role that must be given a careful consideration. The arbitral tribunal takes its jurisdiction to decide a dispute from the agreement between the parties. An arbitral tribunal does not get its jurisdiction from any legislation. The scope of the tribunal's jurisdiction will be determined by the scope of arbitration agreement, subject only to any mandatory legislative enactments governing the arbitration agreement. That's why it's very important for the arbitrator to be knowledgeable with uh, laws, okay, substantial laws, and the nature of the institution's laws. Under the theory of party autonomy, if two parties have the legal right to settle a dispute between themselves, then they can give jurisdiction to a third party to settle it for them. Um, Commonly, the party who seek advice for mediation to institutional arbitration center are those disputes who are really complex or big or serious in nature. They are not talking about $100. They are talking about $1 million worth of product. That's why they are going to the International Commercial Arbitration Center to seek help and to help them decide, okay, to help them decide on the matter of the cases. What are the provisions, rules, and law that may include in regards with the obligations and the power of tribunal court? First, parties' agreement to arbitrate. Okay? So the scope of jurisdiction of arbitrator will come upon and take place within the agreement or the consent of both parties. Secondly, the applicable arbitration rules may apply. Take note, the power of the tribunal court may take place depending on the type of arbitration they're going to use. If it is only ad hoc, okay, if they're going to follow their own rules and regulations, and or they could follow the ancestral rules and regulations. If it is institutional, they need to follow the rules and regulations or the proceedings of of a particular institutional arbitration. And the third one is the law applicable to arbitration agreement. Whatever it is stated in the arbitration agreement must prevail and it must be followed. What is only written in the agreement that will cover the authority or power of arbitrator, that could be the only coverage of the power that the arbitrator should follow and possess. And the last one is the law applicable for arbitration proceedings. If you follow a particular institutional commercial arbitration, you are going to follow their rules in terms of the process or the step-by-step procedure on how they are going to solve the dispute. You have to comply, you have to follow their proceedings. Of course, upon the application, you know what are the different requirements, okay, if you wanted to follow the institutional commercial arbitrations guidelines. So those are the provisions, rules, and law that may include with the obligations and authority of tribunal court. Now, what are the obligations of arbitral tribunal? The first obligation is independent of the parties. Whatever decision is going to make, it is not being influenced by the bribery or the gifts that had been given to him by both parties. And with that, he could be able to provide unbiased due process. Okay, equally, okay, he must treat the claimant and respondent. He must give favor equally for the claimant and respondent. Third, acquainted with the facts of the case and the claims. He should know the nature of the dispute. He is familiar with the rules and regulation. He should understand what is inside the contract of sale for him to be able to deliver his award, and he could be able to analyze and evaluate the nature of dispute. And the fourth one is to make a reasoned award. If the arbitrator is familiar with the nature of dispute, the technicalities, the terminologies, the terms, and he understood the process and the legality of writing a contract of sales, okay, therefore his decision will be fair enough and reasonable enough, appropriate, okay, for the resolution of the dispute. And last one is enforced award. Upon the assessment and evaluation of the information, evidence, and evidences, okay, the the arbitrator must enforce or must be bravely or courageously implement and award the final decision. That's why it's kind of difficult to be an arbitrator, but if you are equipped with the right information, you are experienced with the industry, and you have a lot of knowledge, okay, with the arbitration, I think this part of enforcing the award would be easily for the arbitrator. In case that there's an absence of jurisdiction or the power, okay, to make legal decisions and judgments, we have four consequences, okay, in this matter. Okay, the first one is no authority to continue with the arbitration, meaning no one is gonna handle the proceedings of the arbitration because no one is legally to decide, okay, on what will be the solutions to be undertaken for the dispute. And secondly, any award made by it will be void in case that the arbitrator is not legally capable. Whatever decisions that he is going to make is will be void or it will not be accepted. And the third consequence says it has nothing to adjudicate. He should not decide. There will be no decisions to make because of the lack of legality or the lack of official power to make decisions or judgments. And the last one is issuance of temporary restraining order. Okay, temporarily, since there will be no legal authority to handle the case, okay, the court is going to make a decision, okay, on their own, and they're going to issue a restraining order. When we say restraining order, this is a temporary court order to prohibit an individual from carrying out a particular action, especially approaching or contacting a specified person. Therefore, the arbitration process will be stopped or freeze until there will be a legal person to initiate and conduct the arbitration process. It is really important to understand the concept of arbitration proceedings because the claimant and respondents will know what to do in every stages, and they could prepare themselves, okay, to submit evidences and defend their sides on the matter of claims. And also the obligation and the task of the arbitration tribunal must be determined so that the scope of the power and the legality, okay, of the decisions at the end of the proceedings will be valid and not questionable. Okay, and I hope that you learned a lot from our chapter 5. If you have any further question, just send a message through my email, and I will be much willing to answer all of your queries. This is your professor, Dr. Christine Joyce Pau. Have a nice day, and thank you, everyone.